I'm going to be diving into a topic that deals with visa processing. And specifically, I'm going to be debunking a misconception that many people have when it comes to family-based immigration. Stay tuned because this could make all the difference for you on your immigration journey. My name is Joshua Goldstein and I'm here to help. I'm an immigration lawyer that helps people just like you reach your immigration goal. I help you break through the barriers that are holding you back. We work with people across the country and around the world. And when it comes to visa processing, there are so many myths out there. And today we're diving into one of them. Now, to explain what this misconception is, what this myth is, I'm going to tell you two stories to illustrate this because it's a little bit of a technical point, so bear with me. Now, this question came from my team. Here's what happened. A permanent resident petitioned for her children. That's what's called an F2A case. The children then turned 21 years old and switched to F2B category. And then later, the petitioner naturalized and became a U.S. citizen. That would move the case into F1 status, except that she technically never contacted the embassy, the consulate, the NVC, or the State Department to tell them that she became a U.S. citizen. So the question is the case in F2A status or is the case in F1 status? How does this work? The thing that's important to keep in mind is that F1, F2A, and F2B are just several of the different priority categories that there are on the visa bulletin, and they have different dates for which they're current. Sometimes F1 is faster than F2B, sometimes F2A is faster than F2B, sometimes the other way around. It's very confusing. It doesn't follow any logical set of order. The point that this person was making is that by not informing the State Department, the consulate, the NVC, or some part of the State Department, by not informing them that she had become a U.S. citizen, she thought that she preserved the status in F2B. In fact, this is wrong. When you turn 21, by operation of law, you move from F2A to F2B. This is by operation of law. And by the same token, when you become a U.S. citizen, if you're a permanent resident, you switch to F1. That's because U.S. citizens are put in a different category than permanent residents. And at this point, the person says, but Josh, I never told them about that. But it doesn't work that way. It works by operation of law. The moment you become a naturalized U.S. citizen, the category changes. That's the way it works. Now, I'm going to tell you another story that will illustrate this even better. We had a client. He was a very, very dear client. We worked with him for many, many years. He was a permanent resident. He petitioned for his wife. He had 3 kids, and they were all included in his wife's case because permanent resident are preference petitions. Permanent residents are allowed to have derivative beneficiaries in the same petition. So if you file an I-130 for your spouse and you're a permanent resident, the kids are all included in that case. If you become a U.S. citizen, you do not get the same benefits. So you have to file separate visa petitions for each child. This is by operation of law. Green card holders are actually given preferential treatment over U.S. citizens in this regard. If this makes no sense to you, you're probably understanding it because it doesn't make much sense. Congress probably intended for citizens to have more rights than permanent residents. Nevertheless, these are the laws that we have, and we have to deal with them as they are. Back to the story. Our client, our dear friend, a petition for his wife as a permanent resident. His wife had the interview. The kids had the interview. The case got stuck. Meanwhile, he applied for naturalization. He was about to get approved for naturalization. To be a naturalized U.S. citizen is to be in a better position than a permanent resident, right? You would generally think so, but that's not the case. Had he become a U.S. citizen, the case would have switched to a different visa category. And what would have also happened is that his children would then be screwed. They would be stuck because they would not be included in this petition anymore. Because permanent residents are allowed to include derivative beneficiaries in the same visa petition. U.S. citizens have to file separate petitions. Regardless of whether he informs them of this change in status, the change would happen by operation of law. The takeaway, the key point, is that you have to understand that when you switch from permanent resident to U.S. citizen, by operation of law, it sets off consequences. It's going to change the category, and there may be other impacts that you haven't thought of. That is why, before you become a U.S. citizen as a permanent resident, you have to think this through. You have to look at it from every angle and don't just assume that one status is better than the other. And that's why we're here. And if you have questions, leave them in the comments below or reach out to us. We're here to help you reach your immigration goal. You can do it.